Online Safety Act. As our witnesses know, Ofcom is currently consulting on introducing additional safety measures into its existing codes of practice under the Online Safety Act. Today we'll be examining the proposed new measures aimed at improving protections for children online. This session is being broadcast live and a transcript will be taken. Our witnesses will have the opportunity to make corrections to that transcript when necessary. Could I start by asking our witnesses to introduce themselves, starting on my left?
Yes, thank you. I'm Rani Govender. I'm the Policy and Regulatory Manager for Child Safety Online at the NSPCC. Thanks very much for having me today.
Hello, I'm Andy Burrows. I'm the Chief Executive of Molly Rose Foundation. We were founded by the family and friends of Molly Russell after her death in 2017.
Thank you.
Hello, I'm Baroness Kidron. I'm a crossbench peer and I was involved in the pre-legislative committee on the online safety, what is now the Act, the bill at that time.
Thank you, and all very welcome. I'll start by asking the first question. Could you each give us your overall assessment of the additional measures proposed in Ofcom's consultation? I don't mind who starts. Baroness Kidron?
That's a very big question. I think that maybe best, because we'll go into detail, I presume, just to say I broadly welcome that Ofcom has answered some of the questions that we had, particularly putting something forward on live streaming, looking at the user signals across, across different platforms and so on and so forth. So there's plenty to look at and to be pleased with. But I think that the nature of the way they're doing it is so incredibly slow and iterative that some of the fundamentals are not being addressed here. So I would say, just very briefly and broadly, things like safe harbour. If we keep on getting tiny little increments of change and we leave the big gap in outcome, but everybody's off the hook, and the incentive of safe harbour is not to do the best, but to do exactly what you are told, that's a very big problem for the Act. I think also they haven't completely looked at some of the gaps that we all identified, for example, different ages, different experiences for different ages, being more concentrated on risk than process, outcome than process. So there are these big things that all of us, I'm sure my colleagues will back me up on this, have been asking for, that they haven't taken this opportunity. So I think just at the outset, if I can be really clear, I think the Act itself has come in for a bashing over the last couple of months, some of which I think is misinformation and not right. And I think we are better in the world for having an Online Safety Act than we were before, and I want to make that utterly clear. But that is quite different from being a little bit more critical about the rate of progress and the scope of progress.
Thank you. Andy?
Thank you. Yeah, Ofcom has themselves described 2025 as their year of action. And if this is the showcase of what the current framework of the Act and how it's being implemented is delivered, what that looks like, then we are underwhelmed. There are welcome measures in the codes, and I will welcome any strengthening of the first set of measures to better protect children. But as Baroness Kidron said, this gradualist approach is slow, it is reactive. We are seeing measures like live streaming being addressed in this second volume of the codes. I think that is primarily a reflection of Ofcom's bandwidth and of how they are implementing the Act, rather than necessarily starting from the point of tackling harm. We're also concerned that some of the measures in these codes risk cutting across and potentially undermining the earlier protection of children's code. And I'm thinking there that Ofcom rightly designated forms of non-designated content in previous consultations, and put a measure on platforms to ensure that platform algorithms were not recommending that content where that content had been detected. There's then a substantial gap here, because the measures around proactive technology that are being proposed do not apply to NDC, and they also do not apply to illegal self-harm. So that would appear to undercut the previous iteration of the codes, and certainly in the discussions that we had with the regulator when the Protection of Children Code was first launched, we were urged to see that as the first of 2 consultations, this being the second one, and at the very best, they are not joining up effectively.
Thank you. Rani?
Thank you. Yeah, I would echo the points about being overall certainly supportive of how Ofcom have recognised the gaps that were raised around the previous consultation, and they have acted on those. I think that's a positive sign. Agree on the kind of concerns around the time this takes. I would just also pick up on the proactive technology measure, but certainly recognising Andy's point about the kind of limitations to it in terms of what it does apply to. But in terms of kind of how it is looking to address child sexual abuse, I think it is a really welcome measure in that respect. I think what's particularly welcome about this measure is it isn't prescribing 1 or 2 specific solutions, tools that companies should be using, but actually putting that onus back on the tech companies to do that work, which is where the responsibility should be. They should be the ones that are looking at where the risk is on their services and what tools are out there to best tackle it. I think that's absolutely the right approach in terms of how Ofcom should be looking at tackling these harms and really driving that responsibility on tech companies to do a much better job. Clearly there's much more to do on this. Andy's illustrated some of the areas we could see this expanded for this measure, and I think just generally looking, as Baroness Kidron has said, what are the outcomes we want companies to work towards, and then having those expectations clear is a really important next step. So yeah, overall, all welcome what we're seeing today, welcome today what we're seeing, but certainly more to keep building on.
Thank you. I mean, the response is really welcome, but you're commenting gradually, slow, reactive. Are there any benefits that you see towards that iterative approach, or if you could all just say whether you think that should be changed, that's not the right approach that Ofcom are taking? I mean, is it just speed? Do you want them to speed up? Or?
No, I think it's a very difficult question, that, because iterative could be, you know, careful, looking at cultural change, changing the narrative, moving, you know, bringing everyone with you. And if that was what iterative in this context meant, I think we'd all be very for it. I think iterative as we can only do this bit and then we'll do that bit, I think it is as much an opportunity for further lobbying, diluting, mismatching, as we've already heard from Andy, as it is for being careful. So I absolutely understand the idea that we are building one code on the other, but we are not seeing that is building to, you know, a golden future that has been described. And I think that's the problem. Iterative has to actually mean we're all going here, this is what it's going to look like. Don't be impatient. This is step 2 out of the... But we don't have that horizon in front of us. In fact, the people represented here are constantly saying, this is our horizon. Are you going to meet it? And Ofcom are not willing to quite have that conversation.
And I think we still are seeing in this second iteration of the codes essentially measures that are baking in the current industry response rather than incentivising safety by design and taking us beyond what the status quo currently looks like. So, I mean, if you look at some of the specific measures that are being proposed in this consultation, for example, the user sanctions policy or the use of proactive technology in respect of suicide, they are both potentially welcome and powerful measures, but the way in which those measures have been drafted focus on accuracy rather than accuracy and an articulation of the outcome. And when we look at the current state of play, I mean, if you look, for example, at proactive measures, we undertook analysis based on the Digital Services Act data out of the European Union of 12 million content moderation decisions. we saw there that 98% of the decisions by 6 major platforms are taken by 2 of them. So 2% of the total content moderation decisions relating to suicide and self-harm, that combines Instagram, Facebook, Snapchat, and others. So we already have those measures in place, and what Ofcom's measures are doing are simply requiring that is the case, but they are not making sure that they reach a certain threshold, a certain standard. And when the data is showing us that already those measures are being employed with wildly divergent results on platforms that, yes, have differing functionality, but all kind of are much of a muchness in many respects, then the lack of that outcome focus, the lack of an articulation of what it is that platforms should be striving for, means that then the overall effectiveness of these measures will be quite blunted.
Rani?
And I think, I agree with all of that. I think what I would add is, if we're seeing this iterative approach, clearly we all welcome that the code's being strengthened and built on over time, but I think we have to do the best job we can now of tackling the harms we know exist. There is a huge amount of evidence and research out there in terms of where these risks lie and what's enabling them. And if we look at, say, something like how perpetrators operate online, there's much more we could do to attack what's like a decade-old, understanding now of those patterns of behaviour. I think the other kind of solution that we would again push here, it goes back to this point around future-proofing and how can we make sure that the measures stand up to a constantly evolving online landscape. I know we'll talk a bit more about emerging harms, but I think, again, that's why we really welcome any approaches that are putting that responsibility on tech companies to have really onus risk assessments. I think we'll need a lot of transparency around what's in those risk assessments and what companies are doing off the back of them. But I think they're a crucial lever. And the more kind of code measures that there are that push companies to consistently think about how they should be evolving their own practice and not always waiting for Ofcom is going to be really important.
The final point I'll make is a question that I'll put is how can Ofcom, and where relevant, the government actually keep pace with the latest developments in online harms and technologies? Do we think they're not doing that, or any advice on how they should be doing it?
Well, I think it sort of tangentially raises something that I'm concerned about, which is that we've had a number of debates in the House that sort of identified gaps between what we thought as parliamentarians the Act brought forward and how Ofcom has interpreted it. So I think that actually the government could play a very useful role in sorting out that gap. So, for example, Baroness Morgan was successful very much at the last minute looking at making sure that risk as well as size was going to be a factor in categorisation, and then it wasn't. I similarly had something around addiction, so addiction in its own pure terms, not around content, and that wasn't adequately reflected. So I think that the government could do a very useful job here of saying, actually, we interpret Parliament as having said X or Y, and make sure that without encroaching on the independence of the regulator, that Parliament's will has been interpreted. I think the government could do some other things in relation to safety by design and perhaps to looking at safe harbour and so on. And I think I specifically want to say this because although we're sounding very critical of Ofcom, I think we have to be very careful in saying there are the things that we failed to do with the Act that would empower Ofcom, the powers that the current Secretary of State has to actually make an intervention that would help Ofcom, and then those things that we, or certainly I am saying, Ofcom could do better, and then of course all the things we very much welcome. So I think that we have to see it as different packages of action rather than a single, can we catch everything?
Was it on that point?
Yes. I just want to go back to safe harbour. I'm slightly confused by safe harbour because you're worried, and you, Ron, talked about how you thought that it allowed them to respond in the lowest possible way rather than really raising their game. Should there be safe harbour? What's the point of safe harbour? Don't we just want to make sure that the outcomes, that the process and then the outcomes are as good as possible, and not to give them this opt-out, I mean, this safeguard? I mean, one of the points of the Online Safety Act was to get away from the idea of safe harbour, which we had had for publishers, that didn't we? B-Ban.
Well, I look forward to your recommendations. I think just to be clear, Safe Harbour has an interesting function if what it does is incentivise a company to do their absolute best and not be punished for doing its best. So I think safe harbour as a concept is very interesting. And in the American versions of the age-appropriate design code that I've been involved in, we put safe harbour in as an incentive to say, if you do everything and something goes wrong, it's okay. The way that it's worked in the Online Safety Act is that if you do Ofcom's 44 measures, or whichever number it is now, then you're fine. Now, you can choose to do something different. But if you do something different, you don't have safe harbour. And that's a problem, because if what you could do is different, quicker, better, more advanced, more thoughtful, more nuanced, you could actually not have safe harbour for doing the better thing. And I think that's why we're talking about it as a negative incentive in this instance.
Surely, if you do the 44 things that Ofcom tells you to do, you have safe harbour, and then anything above you do that, you still have safe harbour. What's the problem with that?
I mean, I think maybe one thing I'd add, particularly in the context of this question around emerging risks and tools, is that we would expect companies, particularly the large services, to be doing really thorough risk assessments where they're gathering a lot of data and evidence and genuinely understanding what's happening on their service. And there's lots of reasons why they might be a step ahead of the rest of us, because they ultimately have the power to collect that data. Now, if they're spotting new trends, new ways that harms are developing on their platform, but there isn't anything in the codes of practice that address that, then there is no obligation on them to address those harms. So when we're thinking about how do we stay on top of emerging harms, well, there has to be something that forces companies, once they've identified them, to immediately take action and look at what they could do to mitigate them. And at the minute, there is not that incentive there.
Andy, do you want to anything you want to add?
Can I just add one tiny thing on this, which is the other thing is that it puts an enormous pressure on Ofcom. Yeah? Because Ofcom always has to be right about what the answer is if it is their measures that give safe harbour. And I think that is a problem too, because it sort of fixes them in sort of spring 2024 as the perfect time of what was available then. And I think that's a pressure that any national regulator should not be under, that they should be under pushing the outcomes and determining the floor, but not determining the route to get there. I think that's really the heart of the problem.
Really helpful.
Andy, did you?
No, and I completely agree and want to second that point. The problem that we are seeing with safe harbours is not necessarily with safe harbours per se, but it's then the way in which safe harbours are working when they are interplaying with the approach that Ofcom is taking, which is risk averse, and so we are resulting in codes that effectively just reinforce and bake in the status quo. There's another point that I would make here, though, around being able to respond and keep pace with emerging and agile technologies, and so therefore also agile and evolving threats, which is about the evidentiary threshold. Now, Ofcom are applying a very high evidentiary threshold, presumably in order to try and safeguard the measures from JR and challenge from industry. But that creates a challenge because clearly we are talking about harms that are, evolving at pace. And so the challenge in generating evidence to meet that threshold means, that we have, again, a slow, reactive response. And a specific point that I would just make is that, there are areas where I would be critical of Ofcom's agility in identifying and responding to some new harms. So one of the things that worries us tremendously is the threat posed by comm groups. So these are groups of young men being groomed as perpetrators, drawn together by fluid ideologies. We are seeing them commit a whole range of truly appalling harms, including essentially a new type of grooming focused on suicide and self-harm, driven by sadistic behaviours. I first warned Ofcom of these groups in January 2024. We've seen, I think, 6 advisories from global law enforcement agencies. The FBI most recently warned of a sharp increase in the threat. There is still no evidence that the codes have been drafted to account for the risks posed by these groups. And when the Register of Risks was updated in December, there was a scant passing peripheral reference to this. Now, as someone who's worked in this space for a decade, I have to say this is probably one of the threat types that I find more disturbing and chilling than anything else that I have seen. There are law enforcement agencies who are queuing up to say that this is this is a huge concern, that we are starting to see children and particularly girls being groomed for purposes of self-harm and suicide. The most appalling, egregious acts of harm, stories of girls being coerced into self-harm acts relating to the groups. And I've heard from parents here in the UK who are desperate to see the regulator take action, and some of those risks are not being recognised. Now, that is not consistent across the piece. On something like child sexual abuse, I think Ofcom are doing a very good job of understanding and articulating the risks, but on these newer harms, they are not where they need to be.
Thank you for raising that. That's helpful. Is it on this, Charlotte? Yeah.
Yes. Can I just follow up on that question? From your understanding, do you think that's a capacity issue or a lack of horizon scanning on their part? Where is the fault lying?
I think some of it is capacity, but I think a lot of this is horizon scanning, and it feels to me like there has almost been a failure of imagination to be able to conceive of what, say, suicide and self-harm offences look like. I think the regulator have a very good understanding of the way in which algorithmic harm, such as that which contributed to Molly's death, plays out. But the nature of offences, where we are ostensibly talking about grooming, so in the way that we will see grooming for purposes of sexual gratification or grooming for purposes of financial motivations, new types of grooming driven by the darkest type of motivations that we can think of, kind of sadistic motivations and a whole melting pot, a melange of harm types. I think there hasn't been the appropriate horizon scanning, and I think that has kind of bounded the constraints of then how Ofcom is viewing the problem.
May I just come in on that briefly and just say, I think that this is also connected very closely with this idea of what evidence is. And I do think that there is an argument to say, talk to young people, they will tell you this is happening. Talk to parents, talk to teachers, and this idea of the classic evidence has not been accompanied by accessing the evidence that sits within the tech companies. So I would be interested, I don't know whether the committee has asked Ofcom how many information notices that they've sent to say, since they had the powers, but when I checked a few months ago, it was none. Even though they had the power. So I think the question is, where is the evidence going to come from? And if the evidence isn't going to come in the form that Ofcom would like it, what other signals are they willing to take that means that 2 years later we're still without evidence? And I will put on the record that we did get a research access during the passage of the data bill that was very, very important, thanks to Viscount Colville.
Thanks both for raising that. That's very helpful, and thanks to Charles for doing that. Let me move on to Veronica, Baroness Fleet, for our next question.
Thank you so much for coming in. We do really appreciate it. I know how busy you all are, and you're absolutely steeped in this subject. We have seen a real lack of public trust in age verification, and the whole issue of VPNs has people are very aware of it now. And I just wonder whether you think that what Ofcom is proposing now to extend the age verification will actually work, and what do you think that Ofcom have learnt lessons from the first stage? I mean, it overlaps a little bit with what you've been saying now, but can you see any benefits of using HEAA to target at child safety settings at child users as opposed to applying them to all users? Where would you draw the line on that? Would you like to start?
Well, I might answer the piece of your question that is, have they learnt the lesson from the last round, and try and tackle that. I mean, I had a private member's bill on the subject of age verification a few years ago, and a great deal of it was actually moved into the bill and is part of the Online Safety Act. But the one bit that was not adequately reflected, and there is a great deal of evidence in Hansard that we discussed this ad infinitum, was the question of privacy. And I remember standing in the chamber and saying, it will never be acceptable to the adult population if age assurance isn't radically private, if that isn't at the core. Now, I will say, and I don't want to misspeak here, because Ofcom does say it should be privacy protecting. They do say it must meet the ICO codes, but it's all very roundabout. And I think that one of the things that I would like to know, and I will in fact write to them, but the committee might consider, is asking what is happening when people are introducing age assurance in a way that is not privacy preserving. So if someone's asking for a driving license or a passport unnecessarily, if someone's asking for more data than is actually required to establish age, that is going to fundamentally undermine people's sense of safety in the information that they give, particularly, let's face it, male adults who are trying to access pornography because they don't necessarily want the social embarrassment. So I think that what I would now like to see is a recommitment on privacy, and I would also like to see Ofcom use its powers to say that where it is not privacy preserving, age assurance has not met the bar of being highly effective, because it's not highly effective in a cultural sense, even if it actually determines whether you are 18 or not. I have some more complex views about whether it should be 18 or, why they're not doing age appropriate more generally. But I think in answer to your specific question, I think that unless we get the privacy right, we will never get proper acceptance of this idea.
You had a specific question, didn't you? About
yes, I just want to really try and pin you down. I mean, particularly after you spectacularly failed to get an answer yesterday on your question. It's a dismal session. You talk about the importance of pinning down privacy when it comes to age verification. I'm still not absolutely clear what the details you want are, because there is a privacy provision with age verification isn't there, on when you go into most sites where there's thought to be a risk and there's need for the age verification. What is extra? What are the details of what you actually want to happen to make sure that data that is given up by adults who have to pass through age verification can keep their data private?
I think that the data, well, I think there's two parts of it. I mean, I think probably on paper we're closer to my position than not, but I think it should be a requirement written down in code that data used for the purposes of establishing age may not be used for any other purpose.
Right.
Yeah? And when checking age, you must not check other things like location, gender,
right.
anything else. So assuming that is the understanding of what data minimization is, then you have to question whether the companies are doing it. Now, there's a lot of misinformation out there, and that's the bit I can't speak to. But the misinformation is saying, I don't want to give my passport in order to go and access this, that, and the other. And it should not be necessary to show your identity, but only the signals of age. And there are very, very good ways of doing it, and there will be increasingly good ways of doing it. And I'd be happy to write to the committee, with outlining some of the age assurance methods that do work, that are privacy preserving, and so on. I don't think we should. I should detain you right now with it, but I think this is a core thing. Is it required? And if it is required, is it actually being implemented, that requirement?
Veronica, I think it's kind of back with you. If you your original question.
I think that's fine because it all links in together, so you've covered the points very well. Thank you. Andy, would you like to add anything to that, or Rani?
I would just briefly build on the point that Baroness Kidron made about it being over to Ofcom to be taking enforcement action not only against platforms that have not introduced any form of age assurance, but platforms that have not met highly effective age assurance, whether that is through the privacy lens or whether that is through the other characteristics. Now, there was always going to be a sea of controversy and a sea of misinformation this summer. I think that was inevitable. But certainly some of the examples that were being identified in the first few weeks of age assurance mechanisms that could be fooled, for example, by using an avatar photo, that would raise questions to me about whether that is a highly effective measure that is being deployed. So I would like to see Ofcom act quickly, because public trust here is precious. Clearly there does need to be privacy preserving mechanisms, and we know that they exist. And I think, enforcement is now the best way of being able to demonstrate to the public, A, that this can be done, and, B, that where we have seen high-profile examples which have generated public concern, that is a reflection as to whether or not we have seen compliance, rather than, as it has been framed, whether or not this can be done.
Yeah, I mean, I echo much of that, and so maybe I'll just take the other part of the question, which is around the kind of extending use of it and applying it to different settings. So, I mean, I think recognising all the challenges we've faced, we also, highly effective age assurance will have to play a role in the new regime. We can't give children enhanced protections if we can't identify who they are. So we have to get it right, and I think we've discussed that a lot. In terms of applying it to kind of particular safety settings or not, I mean, clearly there is a benefit of the universal application of these safety settings, because it means whatever age a child might have managed to create their account at, and whether that's a child or adult account, they'll benefit from these settings because they'll be everywhere. But there are real trade-offs to this as well. So if we take the grooming settings that are being looked at and having age assurance applied to, they are part of a two-track approach for tackling grooming. We've got the settings, and then also the requirement that services have to share user support information at key stages. So when a child goes to turn off a setting first gets a message from someone that's a new contact online, for example. Now, if that user support is no panacea, it's not going to solve everything, but it has been recognised as an important part of Ofcom's approach. And so if companies aren't able to identify children, they can't tailor that information so that it's age appropriate. It speaks about risks that children face, that it signposts them to the right kind of services that are child specific. So yes, where we can be agile and where we can take different approaches, we certainly should, but I do think it's really important that we are in a safe way and in a proportionate way, because I suppose that's also important on proportionality. Some of these settings users won't have the option to turn on or off, like the live streaming ones we'll come on to. They need to be on for children and they can't change them. And that's right for children, but you might say, is it proportionate to get age checked, but also is it proportionate for adults to have these settings that children have to have? There's going to be compromises to a lot of this, so I think they're discussions we have to keep on having, but from our perspective, age assurance is going to be a really important part of that.
One very quick last question to Andy. You mentioned that the Ofcom must take action. I mean, are you aware of them, limbering up to take action? I mean, are they actually taking action, or are they just talking about taking action? Are you aware of platforms that are already under investigation and being put on the spot?
So I think Ofcom has said that they've launched several dozen investigations, I believe primarily against sites that have not complied. Yes. At all. Most of those have predominantly been focused on small pornography companies and not on kind of other parts, other services where we've seen some reasonable questions about whether the highly effective threshold have been met. Now, a lot of this may be taking place through supervision, and clearly that is a relatively opaque process, so we aren't subject to what activity is taking place. But I think public proactive enforcement is a great way of being able to reset the narrative and tackle some of the misinformation that we've seen here.
Thank you. Is that okay, Veronica? Tom wanted to come in.
Just getting the position of where Ofcom is in here of this. I mean, are you saying that Ofcom should be maximising its powers and seeking to test its powers? And there's always the danger with any regulator that if it does so, it will be accused of overreach and such. So where in the implementation of these powers does the responsibility of ministers lie? I mean, there's always a danger with legislation that once it's passed, the caravan moves on, and if you go to a backbench MP, they'll say, but we dealt with that with the online safety bill. Now, you're saying that there were lots of holes. How much do you think Ofcom has the bottle and the desire to stitch up those holes?
I think the reality is that we will see the platforms try to pursue legal challenge whatever Ofcom does. And I would hope that the message that the new Secretary of State is giving to Ofcom's chief executive is that the approach would be that they should be trying to use their powers in the most muscular, assertive way, and sending a signal to industry that they intend to enforce the powers available to them robustly. I think if you contrast Ofcom's approach so far with that, say, of the European Commission and their enforcement of the DSA, the public messaging has been very different. And, I think my impression would be so far that I do not get the impression that the companies are quaking in their boots at Ofcom's enforcement approach. Some of this, as I say, may be taking place, under the guise of supervision, but that is an incredibly opaque process, and so it's difficult to be able to conclude whether that is going to be effective and whether that is sufficiently industrious.
I think that on this particular issue of age assurance, Ofcom have the power, and they should be both insisting that highly effective is highly effective, and that privacy is a core concern and that they are working with the ICO to deal with it for reputational reasons. Only at the point at which they hit a block and say, we cannot enforce against this, is it a ministerial problem. So I think this specific piece is actually in Ofcom's purview right now. And I did want to just recognise that they are going to, or they intend to, embed the right of appeal as they have on age assurance in illegal codes, just like they did in the Children's Code, and I think that's very welcome and a very good idea. Just to be clear, I think your broader point is that unless Ofcom really do test the powers they've got, then they can't turn to ministers and say, do you know what, you got that wrong. And I would absolutely say, in defence of Ofcom, that the bill or the Act is wrong in certain places and does leave certain gaps and will need some more work. And I would say that, when we had industrialisation, we had 17 Factory Acts, not just the one. And this is a new area of industrialisation, and I think we will, in fact, have more. But the frustration is that actually where it is clear and where it is mandated, we don't want to see them stroking them and saying, come on guys, do it, do it, do it. We want to see them taking action, being robust. And I'm very sympathetic to Ofcom in anywhere where they feel they need a power and it has not been provided by Parliament.
I'm just aware of the time and we should move on to our next question. Ronnie, you wanted to make a point? You want to make a point as well?
No, I'm happy.
Okay,
that's covered
fine.
it, yeah.
Okay. Well, I'll thank you for those responses. I'll come on to Baroness Healy-Anna with the next question.
Okay. The committee is very concerned about live streaming, and especially as Ofcom states that the majority of CSAM identified by the Internet Watch Foundation derives from content captured from children's live streams. And I'm just wondering, I'd like to ask each of you, are the proposed safeguards around live streaming adequate to protect children? If I may start with Ms. Govender.
Yeah, of course. So, we really welcome that Ofcom have heard the concerns from civil society around the risks in live streaming and introduced these measures. I think if we're looking specifically at those safety settings on children's accounts, they're really welcome. There is a clear evidential link when we're looking at all of those functionalities into CSA, grooming, coercion, and also other forms of harm like harassment and bullying for children online. So they're incredibly welcome steps forward. I think there is always going to be more to do, and I think there is more we can do. I think we'll come on to the point about minimum ages for live streaming, which I'm happy to talk to. The other point I wanted to raise here is that these settings are to go on children's accounts when they're hosting one-to-many live streams. So that isn't many-to-many. And many-to-many can sound confusing, but that could literally just be 2 child users on their individual accounts collaborating to jointly host a live stream, and then all these really welcome protections aren't going to be there. Now that is clearly a gap, and it's also a loophole. It's a very easy way that anyone determined to not have these protections could get around them. I recognise that Ofcom think that there's a challenge because many-to-many can also mean lots and lots of people live streaming to one another at once, and in a gaming environment that looks very different to on some of the services. So we're not saying that they have to mirror the approach in every scenario, but I think one of the urgent next steps that we'll need to look at is this as a gap.
Thank you, Mr. Burrows.
I applaud Ofcom for the measures that they have taken. There's some very welcome aspects of friction that they are building in. The restrictions around children being able to comment or react or screenshot a children's live stream, for example, that's very welcome. I would like to see more upstream measures. So, for example, I cannot see a credible case for algorithmically recommending the live stream of a child, which is integral, for example, to the design of TikTok. Some of the measures around the reporting of imminent physical harm, again, a very welcome step. In respect of suicide, that only covers a suicide act. It does not cover self-harm or dangerous stunts. I would think by any reasonable understanding they would be considered imminent physical harm, so I cannot understand the discrepancy there. Just a broader point that I would make, and this is a function of the Act, not of Ofcom's implementation of it. The focus on live streaming is great, but if you look at private surfaces, 50 people can join a call on Messenger, 32 on WhatsApp, 25 on Discord. And for as long as we see the codes not applying to private message surfaces, then there is the risk that even where we are seeing really welcome steps on public surfaces such as live streams, that then they are just kind of migrating to private channels, because where does a live stream stop and a group chat end if you can be thinking about 50 people on there? And in respect of common groups that I was talking about earlier, in respect of organised CSA, you can see, I think, how it is likely that you would see some migration there.
Thank you, Baroness Kidron.
Yes, I mean, I would second what's been said by colleagues here. I just wanted to add, and absolutely delighted that this has got the focus that it has got. I just wanted to say something very detailed about the flagging, to make sure that any kinds of flagging should be able to be done without being actually in-app or on the service or logged in any way. This is a perennial issue for me, where flagging is only possible within services, and actually you may be a parent, you may be a teacher, someone may have just told you, and you need to be able to alert. And I have had a particularly torturous experience that is ongoing with Meta, where we tried to flag, where we tried to alert them, and where we found their lawyers wrote to us and said that abuse@meta.com is not a monitored email. So I just would like to know that flagging and alerting means alerting, yeah? And then a second thing is that, and I'm not going to pretend to be an expert in this, but I would caution about the sort of a requirement around human moderators. And I think this speaks again to what we were talking about outcomes versus process. I don't care how anybody works out something's going wrong, and the outcome must be that when it's going wrong, it's found and dealt with. I don't know why a human being is necessarily better than an automated solution. Where it is, it should be used. Where it isn't, it doesn't matter. So again, let's not worry about the process, let's fix on the outcome.
Can I ask all of you, should children be prevented from live streaming altogether, or should there be an age brackets under 18, different points?
Yeah, I mean, so we really welcome that Ofcom have kind of, it's not quite a proposed measure yet, but they're certainly open to thinking about it. And I think it's right that the next step with regulation is thinking not just about adult versus child experiences, but how we ensure children are having age-appropriate experiences that consider their stages of development and so on. And I think there is a really strong case for applying that to live streaming. We would propose that setting that minimum age for hosting, certainly on social media sites, at 16 would be proportionate. If we look at the evidence, it is abundantly clear that the huge risk that younger children face on live streaming. I mean, Ofcom's own profiles of how kind of different children behave online in different age groups shows that 10 to 15 group is particularly likely to be impulsive, to risk taken when that's happening in live streaming environments. That's a concern. We also know from that IWS data that in terms of the production of child sexual abuse material, that it's younger children who are particularly at risk there. Some research the NSPCC did a few years ago shows that children that are at primary school age are disproportionately more likely to be asked to remove clothes on live streaming. So I think it's clear that live streaming is far from a safe by design experience for children at the minute. We welcome these measures coming in, but I think given the scale and the immediacy of the harm that we can see in these environments, it does make sense to raise that minimum age to 16 to make sure that 16 and 17-year-olds still have really strong protections, taking proactive steps, implementing these settings and so on, and look how it can be made safer. But yeah, I certainly think that this is somewhere where we can start to take that tailored approach, because one thing I would like to add is that there's been lots of debates generally about children's access to the online world and kind of blanket increases to minimum ages. I don't think that's appropriate. I think there's a huge amount of benefit that children can get from being online, and they have a right to enjoy that. But to enable them to do that, we have to look at where the harm is too extreme and too significant and put those sensible age limits in so that we aren't actually stopping them getting most of the benefits they get from the rest of the online world.
Thank you, Mr. Burrows.
I would agree with everything that Rani has said, and I think, if platforms want to offer live streams to children, then they should be taking further steps above and beyond regulatory requirements to demonstrate that can be done safely. I spoke in my previous answer about if you think about TikTok, for example, where the algorithm of the For You page recommends live streams. I think many of us will have seen circumstances where there is someone who ostensibly looks quite vulnerable and who is a child who is being algorithmically recommended. Now, I cannot see how that is consistent with fundamental principles of safety by design. So if the platforms cannot take those steps, then we absolutely should be looking at, whether we need to be looking, as Rani says, at a functional based application of minimum age points, where we then turn those features off and on.
Baroness Kidron.
I think I was very interested to hear your witness last week talk about putting a delay for children. I haven't thought about that in great detail, and I don't know the research, but I think it's a really interesting idea that should be unpicked. And I do think for very young children it's completely inappropriate. And this is a very good example, I feel, of where it is disappointing that Ofcom did not pick up the various places in the Act where it said age appropriate, so that something, for a 12-year-old, a 14-year-old, a 17-year-old are completely different. And I'd be horrified if live streaming was not available to 17-year-olds, because it seems to be something that they could and should be able to do. But I think we have to come back to this idea of judging the companies on the outcome. So if the outcome of a 17-year-old live streaming is that it is safe and reasonable and not dangerous, then bring it on, say I. But if they can't, then it's actually a dangerous product, and why are we giving it to children? And I think there's a lot more of that thinking that I would like to see as we move forward with the online safety regime.
And may I just briefly add there, because I think it is a fundamental and oft visible point around the lack of measures being articulated around outcomes. When you look at the measures around live streaming, a requirement to have human moderators, great, but what is the outcome? A requirement to have a report, but then what do companies need to do when that reporting function is triggered? We are seeing already that some of the ambiguity in Ofcom's drafting is being exploited. We issued some research a couple of weeks ago that was an analysis of social media platforms in the weeks before the Online Safety Act took effect. And we were starting to see some of the measures in Ofcom's code being rolled out ahead of time, but the ambiguity in the drafting there being exploited. So one of the measures in the Protection of Children's Code is that there should be an opportunity for children to offer negative feedback on content being algorithmically recommended to them. Now, if implemented well, that is a fantastic step that can give children better agency over their feeds. But the way in which both Instagram and TikTok have implemented that is that you can say, yes, I'm not interested in this type of content, but also I am interested in it, and that then results in you being served further similar content for the next 30 days. And we saw repeated examples of suicide, self-harm, intense depression-related material where then, you know, the ambiguity was being exploited, and so, you know, then children would be served more of that content. So outcome-based articulation of what companies need to do is fundamental.
Thank you. I'm going to move on to Charles' question. We're quite short of time now.
Right.
Yeah. Charles.
Hi, this is the final set of questions. I mean, last week in our session, we heard about the use of proactive technology such as hash matching. Do you think that it should be rolled out to analyse user-generated content which is communicated privately? And would this provide, they'd be able to pick up on hints to signpost perpetrators of illegal content communications, do you think? Andy, have you got anything to say about that?
I mean, I would say yes. You know, this is an argument that generates very often a huge amount of heat rather than light, to say the least. But I think, you know, the well-known experts in the field, like Professor Hani Farid, for example, at Berkeley, would say this can be done without breaking encryption, for example, and it is a hugely powerful tool. When you look at some of the research that has been done out of Australia, for example, in respect of CSA by Professor Michael Salter, you know, you can see that on private chats, CSA offenders by a factor of, in some cases, 20 or 30 times are more likely to be using certain platforms. So if hash matching can be done and it is technically feasible, then it absolutely should be done.
Anything to add?
Yeah, I mean, I'd echo that entirely. And just to add that we know that an absolutely fundamental part of the grooming pathway is to typically can often be to start communication with children in more public, more open forums. It might be on gaming platforms and so on, and then to move these communications to private spaces. And so while it's welcome that the proactive technology measures are going to be implemented in the public spaces, and to be clear, this is a limitation in the Act, not on Ofcom, but if they aren't being used in private spaces, we are not using the solutions where they're actually needed, and we're continuing to rely on children to defend themselves. And that was really at the core of the Act, is that we all accepted the burden has been on children for far too long, and that needs to change. But actually, if this harm, and I can only see how it would increasingly migrate to these private spaces as the public spaces hopefully get safer, and I think that's unacceptable. So I think it's something Ofcom do have powers they can use in specific circumstances, and they should go as far as possible with these to compel private companies to act. But again, as we were saying, where they are bumping up against the legislation and can't go anymore, I think that's something the government have to consider.
I would agree with what's already been said. The only thing I want to add is that I've got a particular bugbear where Ofcom has very rightly stopped direct messaging between unknown adults and children, but they haven't stopped friend requests. So an adult can actually make a friend request if the child answers it, an unknown adult. If the child answers it, they can then direct message. So I just think this whole question of how you fish for children in the public arena and then take them into private spaces cannot be a place to hide.
Great. How should platforms handle cases where children themselves upload CSAM? I mean, should children just be banned completely if they start sharing this sort of content without exception? And are there any problems with doing that?
For me, this is probably one of the most difficult areas, and the reason that it is that not all that is happening in relation to that is completely innocent. Yeah, there are some very, very aggressive and purposeful and intentional things that people under the age of 18 are doing to each other or to themselves. And so you can't just go, oh, they're kids, it doesn't matter. But I'm involved in a case with a child of 13 who forwarded a snap sticker that reached the threshold, and it's been months in legal horror with CBS about whether they're going to charge him and so on and so on. So for me, I would say criminalising children is the last resort, absolute last resort, and that culturally and educationally we need to put a lot more resource into trying to help children understand why some of the things that they're doing are not appropriate and not right. But I think some of the other things that we're talking about, safety by design, about amplification, about nudging kids into these behaviours, all have an impact on how many of these kids are doing that, and indeed some of the congregants that are pushing this behaviour. So there is a fine line between victims who are doing the wrong thing, perpetrators who are doing the wrong thing, innocent, wrongdoing, and some messy things around the middle. And that's probably the most difficult thing to legislate for. But I think that we should have a policy that is really criminalising children as an absolute last resort. And I would like to see some more education and sort of, rehabilitation in that space.
So prior to criminalising, is banning those children from the digital space.
I think it's difficult to know what banning means quite, and how far and how long and from what and for what purposes. I mean, I think you have to remember that children's lives are very complex, and it depends what you're banning them from. I mean, there's many ways in which they need to access, perhaps not a specific service, but
you could ban them from a specific service, couldn't you? If that's the service on which they've exchanged.
You could, but I would like to see a slightly more tolerant sort of 3 strikes and you're out, unless it's very intentional. I would like to see something much more educative and much more careful in this particular arena, because children feel very, very bereft at being excluded. And I think one thing that does not come up in these conversations about online safety is the cry from children about what else is on offer. They cannot go in the street. They do not have parks. They don't have after-school clubs. The children I engage with speak very, very much about being kettled into the digital world. And then if you exclude them from certain spaces, that is a punishment upon a punishment. So I think we have to be careful on this particular issue.
What about you, Rani? Do you think that do you agree? Do you think that the banning is absolutely is something that shouldn't be considered in these particular cases, because you're kettling upon kettling?
Yeah, I would say so. So I think first of all we would say that in all scenarios at the NSPCC we want children to be met with that safeguarding response, and if we just leap into bans, that scares children away, and we want to make sure that we're never deterring children speaking up about something that's happened to them, whether that's something they've experienced or something they might have done online. And I think those principles have to be front of mind. I think it is important that we're clear that one of the options Ofcom are currently considering is permanent bans on children, including children who are victims of grooming and online abuse. To us, that is absolutely unacceptable, and we have to be clear that there must be no form of victim blaming at all in these final proposals. And then I think Baroness Kidron makes an important point, though, about some of the lines can be blurred between exactly what has happened here. And I'm personally not comfortable with the idea that tech companies are going to be the arbiter in terms of what's happened to children and making those extremely sensitive decisions. So for us, permanent bans have to be out of the question for children. Where there has been real harm and there's a clear understanding, and maybe that's coming from reports from other children that clear harm has taken place. I think, similarly looking at some kind of shorter term suspension, some sort of strike-based system. It's worth saying that a group of young people that the NSPCC work with online safety have proposed something similar. They don't think that there should be never any consequences ever for actions, but it's important that they're proportionate. From a youth justice perspective, we would not impose the harshest measures on children as we might sometimes with adults. And so if we're saying permanent bans are suitable for adults, that doesn't mean we should just copy that onto children. So I'd like to see an alternative proposal from Ofcom on this.
Andy, do you have a different view, or do you just agree?
I would largely agree. I would say that there has to be a high threshold before considering a ban, and perhaps kind of that is at the point where we have arrangements in place for where the CPS may consider prosecuting a child, and in the vast majority of cases it would not be in the public interest to do so, which is the right balance. So any threshold would need to be set, I think, very high.
Thank you very much indeed. Thank you.
Thank you. That's very useful. We've had a few sessions, and next week we've got a session on with Melanie Dawes of Ofcom. So it's so useful to be able to run through this, and we will be reflecting back to Ofcom what has emerged from this very short look at these codes of practice. So that's just very helpful. Thank you very much indeed for your time.
Thank you very much.
Thank you.